Hey everybody, how are you doing today? My name is Elijah Larson, and I'm extremely excited to be able to be here and to be able to help with this webinar. Just so everybody knows, there's a Q&A feature in the Zoom meeting that you can use to ask questions throughout the presentation, and we will try to do our best to get some of your questions answered. To start, just a little bit of background about me. I'm from Farmington, New Mexico. I'm fluent in Spanish and I have experience working in employment law, obviously, here at Employer Lawyer, corporate compliance, Argentine tax law, among other things. I went to BYU for law school and I went to Brigham Young University, Idaho, for my undergraduate degree. I'm currently licensed in Utah or in New Mexico, and I'm pending a mission right now in Utah. So, as is our topic today regarding whistleblowers and retaliation in the workplace, it's important for us to understand what is a whistleblower. A whistleblower, as you see here, is an employee who alleges wrongdoing by their employer, whether public or private, that violates public law or harms a considerable number of people. Importantly, whistleblowers can either report to the government or they can whistleblow within their own organization. Generally, a misconception that lots of small businesses have regarding whistleblowers is that whistleblowing only applies to big organizations and individuals reporting extreme violations. In our recent culture, I think a good example is in the news within the last year, there has been a lot of coverage of companies like Boeing and AI companies where whistleblowers report things of massive magnitude. But regardless of the magnitude, there are still laws that protect individuals whistleblowing, even within small businesses. So it's important to understand that these whistleblower retaliation laws absolutely apply to your small business. So the big question that we have to understand is, what is retaliation? So for an employee or an individual to have a case of retaliation against an employer, they have to satisfy three things. First, they have to have engaged in a protected activity. Second, they have to have experienced an adverse employment action. And third, there has to be a causal connection between the protected activity and the adverse employment action. So let's talk about protected activities. So these are things that are protected activities. Filing a charge with the EEOC or the State Labor Commission, participating in an internal or external investigation, filing a workers' compensation claim, requesting reasonable accommodations for a disability, requesting or taking FMLA leave, opposing wage theft or unpaid overtime issues, and discussing wage or work conditions with coworkers. Now, importantly, there are many more protected actions. These are some that, in preparing for this webinar, I've been able to identify as can apply to a lot of small businesses and larger businesses as well. But it's important to recognize that a protected activity under the law doesn't necessarily have to be protected. The employee only has to have a good faith, reasonable belief that the conduct was illegal, even if it was not. So if an employee comes and they ask for disability accommodations, or there's an internal investigation and they tell the investigator what they believe is the truth about the situation, that is not something that they can have an adverse employment action be taken against them on the basis of engaging in that protected activity. Typically, engaging in protected activity, the employee can go to HR, the employee can go to an outside agency, as you see here, or they could request in writing something to their management. So it's important to understand that protected activity is a very large category and something that can definitely apply to employees. So the big question is then what is an adverse employment action? So an adverse employment action generally refers to a materially adverse change in terms, conditions, or privileges of employment. Courts generally have held that such actions have to result in a significant disadvantage to the employee rather than a minor inconvenience or small alterations in job responsibilities. Some examples of adverse employment actions include termination, demotion, a decrease in salary or less important or distinguished job title, material loss of benefits, significantly diminished material responsibilities, or reassignment with significantly different responsibilities. Retaliation can also extend to something like poor evaluations in quarterly or annual job evaluations, getting their normal work assignments changed, having probationary periods extended, not getting promotions, and having their work or work hours reduced. All of these things are examples of adverse employment actions, and it's important to recognize that adverse employment actions is generally a very broad term, but it's important to recognize that it has to be significant disadvantage. That's where courts have generally relied on in the basis under which they're evaluating whether or not something is considered an adverse employment action. So, for example, if an employee, just as an example, reports to HR that somebody had been sexually harassing them at work, and as a result, that employee is reassigned to a job with significantly less job duties and job pay instead of action being taken against the supervisor, that would be considered an adverse employment action. And that employee might have been able to fill that part of that three-pronged test, which is protected activity. They went in, they talked to HR, they said, my boss or my coworker sexually harassing me, and then two, they as a result experienced what's called the adverse employment action, where in the example we just gave, they were reassigned to a job with less important job duties and a pay reduction, and three, they can argue that it happened as a result of their report. So here's the disclaimer that I always try to ensure that people understand when we're talking about retaliation is based off of these three things that I've just said. You might be worried that everything is retaliation and that there's really nothing you can do. And so in popular culture, in The Office, there's a scene I love, and I think it's important that we watch it today to understand a little bit better.
Is there no way we can get rid of him?
Not without cause, Michael.
I have cause. It is because I hate him.
Okay, so what do we do then?
Is there no way?
Oh, what do we do when an individual is not performing well or has problems with our work? What we have to understand is what is not retaliation. And one of the great benefits of our law firm and having employer lawyer represent businesses is that we do work on both sides. While the majority of our work is on the business side, we do a lot of work also on the plaintiff side. And because of that, we're able to look at things both from the business perspective and the individual's perspective. One of the biggest misconceptions that we run into constantly is individuals thinking that they've been retaliated against when there was no retaliation. So I just wanted to talk a little bit about some things that aren't retaliation. So disagreeing how to run the business. If an employee disagrees with you how to run the business and they experience an adverse employment action as a result, that's not retaliation. That's not protected. It's not a protected activity. And that's what it's going to come down to. These things are not protected activities. Disputing over work assignments or priorities. An employee thinks it's more important to do one part of their job than a different part of the job. The business owner is able to direct work and tell their employees what parts of their job are what they expect them to complete. And if an employee disagrees with that, that's not retaliation. Personality clashes and communication issues. If an employee doesn't get along with you, they were retaliated against just because you didn't like them. Well, if it's not based on a protected class, then that's not necessarily retaliation. Reporting inefficiencies or mismanagement, if you're telling them that if they tell you they believe you're running the business wrong and that it could be more effective and you disagree with them and they experience an adverse employment action, that's not retaliation itself. If they're reporting something that they believe is illegal activity or activity in which a statute has a retaliation clause, then yes, then that would be retaliation. But simply reporting inefficiencies in the work process and having them experience an adverse employment action as a result in and itself is not retaliation. So complaining about the amount of workload or the stress, that this is when we get a ton on the plaintiff side, where people say that their boss was retaliated against them because they put so much work on them, and they retaliated because they complained about there being too much work. Well, as long as it's not getting over into the disability side and requesting accommodations, then that in itself is not retaliation. So challenging leadership decisions, we've talked about this a little bit with disagreeing on how to run the business, and criticizing coworkers. If an employee is fired for criticizing coworkers, that in itself, absent a protected class, is that they're a part of that maybe had a part to play in the criticism. That in itself isn't retaliation when the employer decides to separate with an employee because they talk bad about their coworkers. So why should you be concerned about retaliation claims? Retaliation is one of the most common employment discrimination charges filed, and about 40% of all EEOC charges include retaliation claims. When we do work with state labor commissions, it's very often that the retaliation box is checked, even if there wasn't retaliation. But the important part for businesses to understand is how this impacts the business. And I think I've captured it pretty well here. Regardless of the merit of the claim, a business may be required to engage in their state's labor commission process. This requires that the business fill out position statements, requests for information, and more. And the whole labor commission process can cost business thousands of dollars in attorney's fees. And even if going past that, there's always the potential of having an adverse judgment an adverse determination by the labor commission against the business, and potential judgments later down the line. So retaliation is an important thing for business owners to understand and to understand what to do. So then we get to the age-old question. The age-old question is, what steps should business owners take when an employee who has previously filed a complaint or blown the whistle is now engaging in behavior that warrants termination? So what can you do to protect yourself when you have an employee who might have complained about something legitimate, but later down the line is let's say they're not completing work responsibilities, or they're being have problematic behavior in the workplace, and you decide you need to fire them? Then we get in to rebutting the retaliation. So on the right, I've laid out essentially how the steps of a retaliation case once you're kind of in the litigating phase and the burden shifting. So first, the employee has to show the three things that we talked about: that they engaged in a protected activity, that they experienced an adverse employment action, and that there's a causal connection between the protected activity and the adverse employment action. After that, it's the employer's responsibility to show that they had a legitimate, non-retaliatory reason for the adverse employment action, for the reason why they demoted this individual, didn't give them the raise, or fired them. And after that, it shifts back to the employee to prove that the employer's reason was completely pretextual. So because that second part requires the employer to demonstrate that they had a legitimate, non-discriminatory reason for the termination or for the adverse employment action, it's extremely important to have good documentation. Now, our firm just last month gave an incredible webinar on documenting the bad behavior of employees, or documenting discipline for employees. One quote that I snagged from that was from Lisa Fowler, where she said, "If it's not in writing, it didn't happen." So that's something I want everybody to consider and to think about, is documentation is paramount in ensuring that a business can defend against a retaliation claim, because it shows that they had the legitimate non-discriminatory reasons for why they were taking the action. So for the key takeaways that I hope people take away from this is that retaliation can occur when an employee engages in any one of a myriad of different reporting actions, whether it's FMLA, workers' compensation, or disability accommodations, or complaining about what they believe is illegal activity from the company. Remember that a protected activity doesn't require that it's necessarily protected, but it requires that the employment had a legitimate reason for believing that the activity was illegal. The second takeaway is that retaliation cases can have a severe impact on the business. They're expensive. Hiring attorneys are expensive. And so it's always better to prevent. One of the great parts of our law firm is everyone here has different experience prior to joining the firm, whether it be at other law firms or in other industries. As I mentioned at the beginning, I worked in corporate compliance for a little bit. And so a lot of the way that I personally look at stuff is trying to solve problems before they even happen. And so that's why it's such a big deal that employers are making sure that they're documenting the bad behavior of their employees, is to ensure that if something happens, they can show that there was that legitimate non-retaliatory reason for the termination. So that is all that I have on retaliation. And if there's any questions, Michelle will let me know, and I'll try to do my best to answer them.
Okay, so far we don't have any questions in the chat, but we'll give it a minute and see if anyone's writing anything. And if there's anything specific, you're welcome to reach out to our team at the number and email.
Yeah, and then just to pull it up again, I just want to show just some examples of what a protected activity is, so that you might have, if any of the attendees have questions about necessarily maybe what that looks like, or what do you do, something we can generally answer.
Mm-hmm. Great. No questions. So I think we can wrap it up. And if there's anything else, just feel free to reach out to us.
Thank you.